Hey guys, what's up? How are you all? कैसे हैं आप लोग? मैं आदित्य कश्यप come up again live with part 11 of CPC MCQ series. Hey guys, what's up? So in this series, we will cover MCQ from previous year, judiciary, APO, and it is also relevant for LLM and other law entrance examination. So this is part 11 of CPC MCQ series, and I am Aditya Kashyap presenting you with that. So let's start. But before that, let's talk about some uh, fact which is must to know about CPC. Okay, so the first one is CPC 1908, which came into force from 1st of January 1909, and its applicability it's applied to whole of India except state of Nagaland and tribal area, and it consists of 158 section and 51 order, and it is a law of procedure, and it is a civil law which apply on civil cases. So these are the fact related to CPC. Okay, now let's start with the MCQ series. Okay, so today we will dealt with section 141 to 158 of CPC. ठीक है. Question number 1. Question number 1 of CPC. In section 141 of CPC, the expression proceeding exclude any proceeding under Article 226 of Constitution. So this proceeding is not talk about the proceeding went in Article 226 of Constitution, and what it states, it state writ under High Court. Okay, so this will not include under the expression proceeding which is mentioned under section 141 of CPC. So this is the first question. Question number 2. Affidavit to be filed in a court can be. So affidavit to be filed in a court can be authenticated by a judge, a magistrate, or a notary. So what affidavit to be filed in court can be? It can be authenticated by a judge, a magistrate, or a notary officer. आगे बढ़ते हैं. Which of the following section of the Code of Civil Procedure Code 1908 makes it mandatory to serve notice in writing only? So this is clearly mentioned under section 142 of CPC, which states that it is mandatory to serve notice in writing only. Okay, so notice must be served in writing only under CPC section 142. आगे बढ़ते हैं हम लोग क्वेश्चन नंबर 4 पे. क्वेश्चन नंबर 4 क्या कहता है? all orders and notices all orders and notices served on or given to any person under the provision of civil procedure code shall be in writing has been provided under. So it is provided under section 142. So notice always provided in writing, and it is mentioned under 142. Okay, आगे बढ़ते हैं. क्वेश्चन नंबर 5 क्या कहता है? क्वेश्चन नंबर 5 कहता है पोस्टेज पावर टू रेमिट पोस्टेज अंडर सेक्शन 143 CPC lies with the so it lies with the state government. So it lies with the state government. Okay, तो power to remit postage under section 143 CPC lies with the state government. आगे बढ़ते हैं क्वेश्चन नंबर 6 पे. क्वेश्चन नंबर 6 क्या कहता है? Power to make up deficiency of court fees. Power to make up deficiency of court fee is given in the Code of Civil Procedure under which section? So it is given under section 149 of CPC. So the power to make up deficiency of court fee is given in the Civil Procedure Code under section 149, right? This is question number 6 for you. आगे बढ़ते हैं हम लोग क्वेश्चन नंबर 7 की ओर. क्वेश्चन नंबर 7 क्या बात करता है? Question number 7 state enforcement of liability of surety. Okay, enforcement of liability of surety under CPC is dealt with in the which section? So, liability of surety is dealt under section 145 of CPC. So, it is dealt under section 145 of CPC. What it state? It state enforcement of liability of surety under CPC. Okay, enforcement of liability of surety under CPC is dealt under section 145 of CPC. क्वेश्चन नंबर 8 क्या कहता है? क्वेश्चन नंबर 8 कहता है under section 148 of CPC the court can enlarge the time not exceeding in total. So it 30 days is the relevant answer. Okay, so under section 148 of CPC the court can enlarge the time not exceeding in total 30 days. Okay. क्वेश्चन नंबर 9 क्वेश्चन नंबर 9 क्या कहता है टाइम फॉर इंस्टीट्यूटिंग अ सूट कैन बी enlarged by invoking which of the following provision. So it can be enlarged by not among the given options. So 151 is incorrect, 148 is incorrect, and 5 is of limitation act is incorrect. So none of these. And it cannot be enlarged more than 30 days. Okay. Where any period is fixed or granted by the court for doing an act prescribed by the Code of Civil Procedure, the court may enlarge such period not exceeding 30 days. Okay, in total. So, where any period is fixed or granted by the court for doing an act prescribed by the Code of Civil Procedure, the court may enlarge such period not exceeding 30 days in total. And clerical or arithmetic mistake in judgment order etc can be corrected under, so it can be corrected under section 152 of CPC. So clerical or arithmetical mistake in judgment order etc can be corrected under section 152 of CPC. The power of a court to correct clerical or arithmetic mistake in judgment, decree, or order. May at the time by the court of its own motion, or may at the time be exercised on an application by any of the parties. So, ये दोनों सही हो जाएगा है ना? या तो मे एट एनी टाइम बाय द कोर्ट ऑफ इट्स ऑन मोशन से भी कोर्ट कर सकता है या फिर may at any time be exercised on application by any party, even the defendant or the plaintiff. So this is question number 12. Question number 13. Question number 13 क्या कहता है? Who has the right to make an application for amendment of judgment and order under section 152 of CPC? So under section 152 of CPC यहाँ पे amendment का application कोई भी लगा सकता है, दोनों पार्टी लगा सकता है, ठीक है ना? Either the plaintiff or the defendant. Okay. So 152 of CPC empower the court to amend judgment, decree, or order in respect of. So it will be related to. It is related to clerical, arithmetic mistake only, and accidental slip or omission only. So दोनों सही हो जाएगा, है ना? आगे बढ़ते हैं. क्वेश्चन नंबर 15 क्या कहता है? क्वेश्चन नंबर 15 कह रहा है जनरल पावर टू अमेंड एनी ऑर्डर एनी एरर और डिफेक्ट इन एनी प्रोसीडिंग इन अ सूट vested in the court by virtue of, so it can be amended by virtue of section 153. So general power to amend any error or defect in any proceeding in a suit vested in the court by virtue of section 153 CPC. Okay. और जब बात होगी क्लरिकल और अरिथमेटिकल मिस्टेक की और एक्सीडेंटल स्लिप और ओमिशन की, तब वो बात करेगा सेक्शन 152 एंड अदर देन जनरल पावर टू अमेंड एनी एरर और डिफेक्ट इन एनी प्रोसीडिंग और सूट वेस्ट इन द कोर्ट बाय वर्च्यू ऑफ सेक्शन 153 ऑफ सीपीसी. क्वेश्चन नंबर 16। क्वेश्चन नंबर 16 क्या कहता है? Which of the following deals with the power to amend, decree, or order where appeal is summarily dismissed in Code of Civil Procedure? So, which of the following deals with the power to amend, decree, or order where the appeal is summarily dismissed in Code of Civil Procedure? So, it is mentioned under section 153A. 153A कहता है कि पावर टू अमेंड डिक्री और ऑर्डर वेयर अपील इज समरली डिसमिस्ड इन कोड ऑफ सिविल प्रोसीजर। ठीक है ना? क्वेश्चन नंबर 17। क्वेश्चन नंबर 17 कह रहा है विच वन ऑफ द फॉलोइंग सेक्शन ऑफ द सीपीसी प्रोवाइड फॉर द ट्रायल इन ओपन कोर्ट वेयर पब्लिक मे हैव एक्सेस। सो ट्रायल इन ओपन कोर्ट is mentioned under section 153B. So trial in open court is mentioned under section 153B, right? And 153A में क्या है? Power to amend decree or order where appeal is summarily dismissed. Okay, to power to amend decree or order where the appeal is summarily dismissed is mentioned under section 153A, and court to be in open court uh, ये 153B में मेंशन है। तो आगे बढ़ते हैं क्वेश्चन नंबर 18 पे। क्वेश्चन नंबर 18 क्या कहता है? It state question says under the provision of the CPC, the court has no inherent jurisdiction to the option first क्या कह रहा है? To restore a suit dismissed for non-payment of the court fees, ठीक है? To restore an election petition dismissed for default, to consolidate suit based on different claims. So all of the above is true. In these cases, the court has no inherent jurisdiction. Okay. Question number 19. Question number 19 क्या कहता है? When proper court fee is not paid by the plaintiff, when proper court fee is not paid by the plaintiff, and the time to the plaintiff to pay court fee. So in that case, the court shall grant time to the plaintiff to pay deficit court fee. Okay, when the court fee is not paid by the plaintiff. Order 20A of CPC applies to which of the following?